Well, good afternoon, everyone. Thanks for joining the Legal Stuff and Regulation panel, by far the best named panel of the entire conference. My name's Drew Hinkes. I'm excited to be the moderator today. We've got an all-star lineup of lawyers, and I'm excited to talk about hot issues from 2019 and what we can expect from 2020 as well. We only have about 25 minutes, so I'm going to skip the perfunctories, and we're going to introduce our all-star panel of attorneys. I'm going to start to my right. Veronica McGregor is a former Big Law partner specializing in cutting-edge payments technology and fintech. She is now Chief Legal Officer at ShapeShift, where she's in charge of global legal strategy, regulatory affairs, and governmental relations. Next, we have Sasha Hodder. She is a Florida attorney with DLT Law Group, where she helps digital currency companies navigate the ever-evolving regulations. Sasha is a frequent guest of the Tone Vay's Bitcoin Law Review show, a guest writer for Bitcoin Magazine, teaches a legal CLE course called Proof of Law, and hosts the Hoddercast podcast. Next is Marco Santori, a lawyer and the chief legal officer of Blockchain.com, the leading provider of cryptocurrency products, including the world's most popular crypto wallet. He was a partner at Pillsbury Winthrop and then Cooley, where he was the author of the SAFT Project white paper. And I'd like to say that I'm kind of honored to be up here with Marco. He was sort of my legal idol when I got started in crypto, and it's a pleasure to be up here with him.
Thank you.
And last but certainly not least is Moad Fahmi, CFA. He's a senior advisor fintech for the Bermuda Monetary Authority, where he heads the department responsible for the licensing and supervision of digital asset businesses under the Digital Asset Business Act of 2018. Mr. Fahmi has held numerous regulatory and financial services positions in his career prior to joining the BMA. Moad was the Director, FinTech and Innovation at the Autorité des Marchés Financiers, AMF, in Montreal, Canada. For anyone who speaks French here, I apologize. So now that we've introduced everyone, I'd like to dive right in. This panel is not going to be like every other legal panel you've been to, where we regurgitate the same thing we've been talking about for 3 years about securities and warn you that you should pay your taxes. Not sure if that brings a lot in the way of value. So we're going to ask sort of a little bit of harder questions and hope to have a little bit of a higher level of conversation. So the first topic today is going to be stablecoins. Stablecoins were a big part of the conversation in 2019. Tether has been surrounded by controversy, has been associated with pumping the price of Bitcoin, and has been under investigation by the New York Attorney General's office for most of the past year. Facebook's announcement of the Libra stablecoin project sent shockwaves around industries and provoked strong reactions by governments around the globe. Venezuela, China, Turkey, and other nations are in various stages of issuing their own central bank digital currencies. Notably, to my knowledge, only one country, Switzerland, has come out with specific guidance as to how these stablecoins should be regulated, while Congress has seen bills proposing that most stablecoins be regulated like securities. So I'm going to start by asking the panel, who is regulating stablecoins the right way? And if you can't name anybody, how should they be regulated? I'll toss it to the crowd.
Marco, you have an opinion on everything, but I'm not sure anyone's doing it properly, or that we even know what properly looks like at this point. You raised Switzerland. Switzerland is taking that sort of same risk, same rules idea. I don't really think that's great, because there's too many differences in things, and the idea of be like saying that if two things are both flammable, then they should be treated the same. But I don't think that. So the risk is the same, but the thing itself is completely different from like hay versus gasoline or something. Things are very different. So the idea that you would regulate something based on the risk it provides and to regulate everything that provides that same risk the same, I don't agree with. There were some good points in there, but I didn't like that particular point.
Mm-hmm. I think that the answer to the question, how ought we regulate, is always a complex one, and it depends on the factual backdrop of the question. But there's usually the same approach that you can take with almost all of these questions, that at least gives you a framework, which is where can we control for risk where the market itself has failed to control for those risks? Identify those risks and then figure out how the market has failed in controlling them, and then find some policy, rationale and some policy implementation that actually does control for those risks in a way that isn't over prescriptive. But in this case, I think there is a clear answer. The U.S. The U.S. is doing it really well. I give these talks in a lot of different countries, and it's actually rare that I get to say, look to the U.S. as a model for regulation. This is one of those cases where I think that it mostly makes sense. The U.S. has taken a risk-based approach to regulating stable coins. There is anti-crime regulation and consumer protection regulation, each on either hand. In the U.S., you can launch a stable coin, and the stable coin risks, by and large, are the same risks that the laws already control for, preventing crime and ensuring consumer protection, right? So there are the same AML obligations that apply to digital currencies, by and large, apply to those who exchange or issue stable coins. And then there are the consumer protection risks, which aren't trying to prevent crime, but just trying to make sure that the money's actually there, where it's supposed to be. And here we have a money transmitter regime that mostly controls for those risks. The stablecoin issuers and exchangers have kind of been shoehorned into that regime, but by and large, it's worked pretty well. On the other hand, the downside is that it's really been a barrier to entry for some new entrants, for smaller entrants to the market. If you put that to a regulator and you say, hey, what could be the possible rationale for preventing young companies, some kids started a financial services company in their garage, why shouldn't they be allowed to innovate? The regulator's answer is usually they should not be allowed to innovate in this area. This is an area for adults, not for kids, and we want to make sure that our citizens' money is protected. Now, whether you agree with that is a political question, but in terms of regulation, it's not a bad approach.
Yeah, just to add on that, I think that, yes, the FinCEN regulation of the stablecoins does kind of make sense, and that's probably where they will fall, but the SEC trying to take any regulatory grip on the stablecoin market, I don't think makes much sense, because we might be on the verge of every country and every company issuing their own stablecoin in the next 10 years, and limiting that only to the regulated national securities exchange wouldn't make sense. And then there's also the taxation perspective. Right now, every coin is taxed not the same as regular currency would be. So if we could have stablecoins kind of taxed just like cash, I think that would be a better model. But yeah, thank you.
Yeah, I think for stablecoins, the questions go beyond only the financial protection and prevention of financial crime. There's also the question of ensuring the integrity of the markets and confidence in the markets generally. In Bermuda, we've taken the approach to provide risk-based regulation to a broad array of digital asset businesses under the Digital Asset Business Act. It's really risk-based, so we can accommodate digital stablecoins issuers, and we intend on publishing guidance specifically on what we expect from these people in terms of capital, cybersecurity, how they should be safeguarding the backing assets, how they should handle the issuance and redemption process. So there are specific things that need to be paid attention to. But one very important thing with stablecoins is that they don't live in a vacuum. So although you regulate the stablecoin issuer itself, they live within a payment ecosystem. So if your stablecoin is issued and it's regulated somewhere, but the exchanges, the payment service providers around it are not regulated, then are consumers really protected, right? So what we try to build is an end-to-end ecosystem where all of the various players become regulated. So then you can really create this system of incentives where there's some confidence in the overall digital asset or stablecoin market. But you can't really achieve that only by saying the person that issues the stablecoin is being regulated. And if those obligations or requirements are limited to financial crime, then I don't know if you're being really protected. I think some of the examples of the stablecoin market, there's some obvious examples where people have said that they have X asset, and it turns out it's not really what people expected.
All right, let's move on to the next question. money transmission regulation remains the frontline issue for almost every company touching the crypto ecosystem. Although compliance can be expensive and time-consuming, financial regulation is viewed as a critical front in the war against terrorism, human trafficking, and the international drug trade. In the US, we saw new guidance issued in 2019 that offered up some clarity, but perhaps muddied up or failed to address other significant issues. The Financial Action Task Force likewise issued recommendations suggesting that more burdensome regulation of money transmission is on the horizon. What do you see as the most important issue involving money transmission in 2020, and how would you like to see it addressed?
I think that balkanization of otherwise permissionless and open networks is probably the greatest threat that the developing global regulatory regime can bring to crypto. In the United States, the regulators have always taken the position that something called the travel rule applies, which is to say the information for a transaction has to travel along with that transaction if the transaction is made between financial intermediaries. So when you send a wire transfer from your bank to another bank, that bank is obligated to send along all of your KYC information to the new bank. Regulators in the US have always taken the position since 2013 that the travel rule also applies to crypto transactions. So if you tell your exchange to send Bitcoin from an address that the exchange controls that's in your name, through an account in your name, to another financial institution's address, well, the travel rule ought to apply to that, but they've never enforced it. FATF came along a year, or just this year, and announced that, in fact, this ought to apply globally. And the reason that the US regulators haven't really enforced this by and large is because nobody else was enforcing it, and so it was difficult to do so in a globally compliant way. Now that roadblock is out of the way, regulators have stated here in the US they're going to start enforcing this. They're going to stop forbearing their enforcement. And I worry that there's going to now develop a caste system of exchanges and intermediaries who are regulated and won't do business with those who are not regulated. And it will sort of drag everybody into this, either into this lowest common denominator of services being provided, or there will be this vertical balkanization between providers. And that's going to be a very different world than the sort of open, permissionless world that we now have, where you can send your crypto anywhere you like, and you can direct your financial intermediaries, like your exchanges, to send your crypto wherever they like.
And to sort of elaborate on that point, it threatens to take away the very basic use case underlying all of crypto, which is the ability to make permissionless transactions from party to party without the overlay of all this government compliance and reporting obligation.
Well, and it doesn't, I mean, I agree with Marco, and one of the biggest problems is just the practical one, right? The system isn't built for that. And so it would require, a major overhaul of how crypto is moved now. And that will be a huge barrier also. So I agree with Marco, but to build on it, it's like technologically not really a feasible compliance right now. So we have to figure out how to do that.
So is it that it's not feasible, or is it that the current architectures don't support the mechanisms to natively move the information that would be necessary from party to party as required by the travel rule?
It's more the second one. It's more that the current architecture does not make this the current architecture makes it infeasible. So.
Mm-hmm. Yeah, so there's kind of two choices a little bit, right? Either you embed it in the protocol, which kind of requires, agreement between the community, the miners, everyone, or you build this overlay, and then this overlay is could be prone to, data protection risk and cybersecurity risk, which, a lot of people interested in digital assets kind of like, they're not interested in having this third-party risk. They kind of trust the protocol itself. But I think regulators have an opportunity to sit together with the industry and consumers and try to think about how do we build something that accomplishes our goals, without being too much of a burden. And right. I think regarding innovation, A lot of regulators worldwide have been, putting in place sandboxes and innovation hubs, and we have these tools. And I think they're kind of waiting and try to welcome people to sit with them and try to build technologies together under their regulatory guidance. And we would definitely welcome, technology providers that are trying to build solutions and that are in need of additional guidance of how this should be applied in the digital asset space. There's, the Global Financial Innovation Network. The U.S. agencies have recently joined. I think they have initiatives around, cross-border testing. This is definitely an area where, cross-border testing of a solution could be done before it actually is, a requirement across the industry. So, I mean, with in a lot of things, it's how do we sit together and try to reach a consensus on these questions? And most regulators worldwide, I don't know if it's the situation in the U.S., but we're happy to sit down and have a proper conversation.
Mm-hmm. And then there's also the issue that the technology sometimes moves faster than the regulations. So we have, well, always, I guess, but we have things like mixers and layer 2 solutions and a lot of wallet providers that don't take custody and then keep themselves a little bit outside of some of the really cumbersome state-by-state regulations and some of the FinCEN requirements. So it's like we're kind of at a crossroads with Bitcoin where some of it's going to be very regulated and very transparent, and the people offering the blockchain analysis solutions are going to continue being very profitable companies and required by most of the bigger exchanges and things like that. And then at the same time, it's rapidly developing privacy solutions that are kind of keeping themselves outside of that regulated space. So it'll be interesting to watch as we go forward how much of that outside stuff gets captured into the regulated space, and then how it's going to impact fungibility if it does become so that some exchanges or some, we already see a few Bitcoin addresses on the OFAC list, how many hops do those have to go before they're cleaned up, and that Bitcoin can be used on an exchange like Coinbase or something like that. So my hope is that we don't get a lot of fungibility issues where the Bitcoin becomes worthless if it's gone through a dark web wallet or something like that. I think that would be really bad for the overall ecosystem. And then just one more thing. I think, Marco kind of wrote the book on the state-by-state regulation in 2013 in your CoinDesk article. It's what I often have referenced. And not that much has changed since then on the federal level, but we've seen so many states coming on board with different regulatory regimes. And Drew, you've done a great job, tracking that on your Twitter every time a new regulation comes out, but I just wish the states would get out of that space and just leave it all to FinCEN.
That is actually in my view, kind of the biggest problem is the lack of uniformity and the fact that it's all like these, state by state, not just enough with FinCEN, but also state by state, and that is not getting easier, really.
Mm-hmm. So Veronica's referring to the 53 out of 55 U.S. states and territories that have their own specific law in addition to that of the federal government that regulates money transmission. And it puts startup companies in an unenviable position of having to choose between permission or forgiveness. They can ask permission and spend millions of dollars on legal and regulatory and compliance and spend a year or two trying to get all of their licenses, or they can go at it and hope that they can afford all the regulatory fines if they're not put in prison under 18 U.S.C. 1960 for doing so.
Right.
And it generally creates an environment that is not facilitative of innovation and upstarts and kind of anathema to otherwise the culture we have here in the United States. And so that I think that if we had this panel 4 years ago, we would have talked about that. And I think that in 4 years, unless Congress does something to preempt the states, which might be a bigger road to hoe than it sounds like, we're going to continue to have this conversation for years to come.
Yeah, it is what I refer to as the patchwork minefield.
Yeah. And there's still, I think, 11 days for comment on the New York bit license has proposed that they're going to create a whitelist. So anyone that's licensed by their bit license has to, what's on the table anyway, is that there's going to be a whitelist of tokens they can list on their exchanges. And if you're not one of those tokens, then the exchange is going to have to ask for permission to list your coin, and then they can do it. And who knows, that might be a 1-year process or something in the asking. So if you're interested in that, there's still 11 days to write a comment in that, with whatever your perspective would be on that. But my perspective is, don't do it.
And for those of you who are interested in getting your arms around how Herculean and unreasonable of a task this is, I'll use this opportunity for a quick plug. My law firm, two of my colleagues, Matt Cohen and Justin Wales, put out a quarterly publication through Thompson, I forget who, I apologize, that chronicles state by state a legal treatise and talks about all of the different regulations related to money transmission, and you can sort of watch the states struggle over time as the publication is updated and see how frustrating this probably is for a lot of companies. We're running a little short of time, so let's skip on to the next one. There's been growing speculation that certain countries like Iran and North Korea may voluntarily shut the internet off from the rest of the world's internet, or that sanctions may result in certain countries having their internet connectivity shut off from the rest of the world. Perhaps certain countries, in order to be defiant or to preserve their own rights, may choose to create their own version of the Chinese Great Firewall of China. So this isn't strictly necessarily a legal question, but I'm asking all the smart folks on this panel to kind of put in their thinking caps here. What would be the impact of a few significant nations that are known to be participating in the cryptocurrency environment or the overall ecosystem, deciding that they want to wall themselves off, deciding that they want to self-segregate? Is this good for crypto? Is this something that would make regulation even more strict? Share your thoughts.
You're not talking about just VPN blocking or blocking certain sites, but you're talking about literally cutting off all the internet to the country.
Feel free to tell me what you want to tell me.
No, I'm just curious, framing the question.
Sure.
Well, I think in order to do that, you'd have to get rid of the TCP/IP system entirely to really block someone off, and I don't think anyone's able to really pull that plug because there's a lot of commerce dependent on the internet.
So suppose that somebody was able to take certain core routers and shut off higher level application layers. They would let IP go forward and perhaps the first couple layers of the TCP/IP stack, but block certain ports that would allow you to do things like use web pages or higher level protocols. What would be the effect of, say, Iran, North Korea, and a handful of other countries that may not love the West, just deciding that they're going to shut off and do their own? What would that do to crypto?
Increase the use of the Blockstream satellite.
Little plug there, Marco.
No, it's good. It's Blockstream, one of my former clients, actually, not blockchain. We don't have a satellite, but you mentioned kind of off the cuff that this wasn't primarily a legal question, and I agree. But it does have some legal implications. In the United States, if a federal regulator decided to enforce against a foreign company, they would use Interpol or some other multilateral treaty process to enforce against that company, because the U.S. has that kind of power, has that kind of clout. They do it every day. Sometimes it's sort of ministerial, other times it's something on the scale of Liberty Reserve, or it's the multinational effort to bring terrorist facilitators to justice. But that's not the tool of most of the world. In other countries, particularly some of the countries that you noted already, their tool to enforce against foreign financial institutions is actually shutting them down at the DNS level, and not getting together a multinational coalition to go and round them up in their home country, right? It's just not going to happen that the Turkish or Russian or whomever financial authorities are going to send agents into the United States to arrest a U.S. citizen in the United States. It's just not how things work in this world. But what they have done, and Turkey has done this in particular with financial services companies, with fintech companies, is look, if you don't have a license, we can try to enforce against you domestically. If we can't achieve that, we'll just shut you off at the DNS level and block the site. So, when you're advising, when you're counsel, when you're advising your CEO and your board on the consequences, because let's be real, that's what management wants to know. Yes, is it legal or not, but also, well, how illegal is it, right? What happens if we decide to take an aggressive position on this. And in some countries, the answer is not, well, you're gonna hire a team of lawyers and you're gonna fight it out in court. In some countries, the answer is just they're gonna block us at the DNS level, and it's gonna be game over in that country. So this is a real issue, and this is something that we think about at blockchain.com when we launch new products. It's something that I always thought about when I advised clients.
Yeah, I mean, that's the reality is that we are not really in the business of giving answers, but so much as risk analysis anyway. But it seems smart people will always find a way to get what they want. And so, I mean, even when certain things are blocked, people find a way around. But when they, depends on, yeah, I mean, how egregious a shutdown it is. Because, I mean, you know, you can block sites, but then people can get around them with VPN. You can block VPN, but people can get around that. And so, yeah, a total blackout might might be actually what happens.
So, Moad, I'm going to ask you a version of this question.
Okay, that's not politically charged, I suppose.
No, nothing like that.
Yeah.
The version of the question is as follows. You are with a country that is innovating and coming up with new expressions of policy. What are the risks to a country like Bermuda that is seeking to innovate but needs to coexist inside sort of the broader world and try to stay within compliance of the general financial regulation? And I'll note that we're short on time, so we'll conclude with this.
That's a very good question. So, I mean, of course, Bermuda is 60,000 people, right? So we are aware that companies, you know, like a Circle, they have a license with us, XBTO, they come to Bermuda and they intend on doing commerce internationally. So when we look at, you know, their business, we evaluate their ability to conduct their business prudently, meaning that they should be aware of the legal obligations that they have in jurisdictions in which they operate. Beyond that, we also have a responsibility to work with the International Organization Securities Commission. You know, we're a very large insurance hub. Bermuda is, you know, some in the top tier in the jurisdictions for reinsurance in the world. So we don't want to jeopardize that reputation, and we actually want to leverage that to build our digital asset ecosystem. So, I mean, every time we make a move, we carefully weigh the you know, the reaction that our peer jurisdictions might have, and the intention is to create a higher bar. I think Marco earlier said that, you know, some rules might lead to, you know, just creating this world where there's this really high bar that nobody abides by, and just, you know, just everyone operating on, you know, under no regulation at all. This is not what we intend. We want to build fit-for-purpose regulation that people actually feel is going to help them achieve their business objectives. But, yeah.
Wonderful. Well, it looks like we're out of time here. I'd like to thank Veronica and Sasha and Marco and Moad for a great panel. Thank you so much.